The state of New Jersey's new concealed carry law, which defied the Supreme Court's Bruen decision, was just struck down in federal court. Federal District Court Judge Renee Baum just issued an order granting a request for a preliminary injunction. Judge Baum had prior issued favorable 2A decisions in this lawsuit and another one, and those were prior TROs that she granted. Well, in this new decision, she just struck a major blow to the New Jersey concealed carry laws that they passed in defiance of what the Supreme Court said in Bruen. Now, before we dive deeper into what's going on with this and what she actually ruled on, because there's some good and some bad, I want to thank the sponsor of this video, which is Blackout Coffee. Blackout Coffee makes some of the best coffee out on the market, and they are huge Second Amendment supporters. If you buy one of their dedicated roasts for like FPC or GOA, actually some of those proceeds will go directly to those organizations so they can file lawsuits like this one here. So go check out Blackout Coffee using the link down below, and if you use the code ARMSCHOLAR, you can get 10% off of your order. Also want to mention that looking at my analytics, I actually saw that 59% of the people who watch my videos are not actually subscribed to the channel. So I just wanted to mention that if you're not currently subscribed, please consider subscribing. Help to grow this channel, help to grow this community so we can get more 2A news like this out to more people. The case we will be discussing in this video is called Coons v. Plotkin. In this case, a preliminary injunction was just granted, and the result of that injunction is that various aspects of the New Jersey concealed carry law is now blocked as unconstitutional. In these lawsuits, the plaintiffs originally sought a temporary restraining order or a TRO to halt the enforcement of the law because it violated the Second Amendment and also the Supreme Court's Bruen decision. Then the cases were later consolidated, and originally in the Coons case, District Court Judge Renee Baum granted a TRO against the state of New Jersey and that new concealed carry law. And we just received news that Judge Renee Baum did grant the preliminary injunction on some aspects of this law. Now, the decision is about 238 pages, but I just wanted to pull out some of the highlights that I saw when I was reading through this, relay some of those parts to you, and also just let you know that this is not a perfect decision. The judge here enjoined some aspects, some restrictions, but she also upheld some under multiple different legal theories, so we need to go through those to see what things she actually struck down and what things she left in place. The judge broke down the review of multiple aspects of the law and analyzed those restrictions using the history and tradition as outlined in Bruen. One of the first things she looked at was the permitting process and the requirement that someone must be deemed to have the essential character and temperament to carry a firearm concealed. So this is one of the permitting application requirements, that you must have the proper character. In this section, she states that according to the state, the legislator based that statutory language on a Connecticut firearm licensing statute that, interpreted by Connecticut Supreme Court, allows licensing authorities to deny firearms licenses to individuals whose conduct has shown them to be lacking the essential character or temperament necessary to be entrusted with a weapon. The state asserts that the Bruen court found such a licensing law permissible, and therefore, this court should deny the Siegel plaintiff's challenge to New Jersey's equivalent law. She goes on to say that it's true that Bruen did make a passing reference to that Connecticut law, the shall issue law, but that doesn't mean that the Supreme Court adopted all those laws wholesale. The fact is shown by the Supreme Court actually saying that even shall issue schemes can be abused, they can be abusive in nature, and therefore they are still open to challenges. Then she goes on to look at the historical context surrounding disarmament laws and the potential for restricting people that the state deems unvirtuous citizens, essentially. On these issues, she concludes that the state can, and I want to emphasize, can engage in this type of conduct. She stated that the state's research, coupled with this court's own, reveal a historical tradition in this nation of prohibiting dangerous individuals or those who would endanger the public from having firearms. Chapter 131's statutory disqualifiers follow that historical tradition and furthers it. Again, like I said, this decision isn't perfect by any means. There are some things that are good in this, and then there are also some things like this that aren't in our favor, and she actually upholds this type of restriction. Then she moves on to the application process requirements, and again, she upholds these types of restrictions. She states that New Jersey argues the new requirements are permissible under the Second Amendment because they serve to ensure that only law-abiding citizens who are not a danger to themselves or others are authorized to possess firearms. This court agrees. Apart from Chapter 131's provisions allowing a licensing authority to request such other information from the applicant and the in-person interview requirement of the applicant's endorsers, The other application requirements seek to filter out dangerous individuals or persons who would endanger the public safety with a firearm. So here she finds no issue with the application process that's put in place, and she finds no issue with it other than the in-person interviews for your character references and also the broader catch-all language of other information that the state of New Jersey put in this bill. Then she looked at the constitutionality of the insurance mandate that this law puts in place. She finds in this section that while Bruen does not demand a historical firearm regulation to be a dead ringer or twin, for a modern firearm regulation to pass constitutional muster, the modern law must still be relevantly similar to the historical law and impose a comparable burden on the right to armed self-defense. Comparing the how and why of the insurance mandate to the how and why behind the surety laws and tort principles the state relies on, this court finds the insurance mandate is too dissimilar and imposes a greater burden on the right to self-defense than the historical laws the state has presented. Therefore, she granted an injunction against the insurance mandates. Then she moves on to one of the larger sections and one of the more important sections, which is the sensitive location restrictions that this law puts in place. The first sensitive location she addresses is government-owned property and how that is different from government buildings. Again, a distinction: government-owned property and government buildings. In this section, she states that the Second Amendment cases that the state cites do not support this sweeping proposition that caring for self-defense in public does not extend to any location in which the government owns the land. In each of the cases cited, the courts found that the government property was integrally connected to a government building that it regarded as a sensitive place, where prohibition on carrying firearms is presumptively lawful. Here the judge is saying that the government cannot just say that they can ban concealed carry altogether at all government properties. It can't be just this blanket ban just saying, yes, this land is government property, therefore you can't carry at this location. Really, it has to be tied in some way to a government building. She said that you can't have blanket bans at all government buildings. Instead, what is required is a well-established historical tradition of those carry bans at that particular type of government building. Then she moves on to a really big section, and the big aspect of this law is the unconstitutional blanket ban on all concealed carry at all private properties. This is the restriction where you would have to get permission from a private property owner or that location to actually carry at that location. Sometimes they would have to put out a sign that would say, yes, concealed carry is permitted at this location. The judge here states that ultimately, the court concludes that the default rule impermissibly burdens plaintiffs' Second Amendment right to carry for self-defense in public as applied to private property that is held open to the public and for which an implied invitation to enter is extended, but not on private property not held open to the public. What this means and what she's pointing at here in this section is she's saying that this blanket ban of concealed carry at all private property is not permissible, especially if that private property is open generally to the public. Think of places maybe like grocery stores or things like that. They are private property, but they're open generally to the public. But purely private property where it's not open to the general public, think of maybe someone's home. Again, a carry ban may be permissible at that location. Now, there's so much more to this decision. Like I said, you could also go to the specific sensitive locations that are targeted in this law. But like I said, this brief is about 238 pages, so I didn't want to make this video too long. If you're interested in looking at all those specific locations, I will leave a link to the document down below in the comment section. Now, the state of New Jersey has already appealed this decision, and they are already seeking a circuit court review, appeals court review, and also likely they're going to seek a stay of this decision. But still, it's a solid win. Again, not perfect, but there were a lot of good things in here, and now you're seeing how the Bruen decision is really playing out and is being used to strike down these types of unconstitutional laws. I will update you guys if we get any more information, but if you want to learn more about what's going on in other states and other two-way battles, you can watch these videos here on the screen. But as always, thank you all for watching. Don't forget to like and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.